All right, then we are here today to hear the oral argument in the case of Willie Jacobs et al. Versus Equity Trust Company. Each party will have 15 minutes to present its arguments. The appellant, who is Equity Trust in this case, may reserve up to 5 minutes for rebuttal. Mr. Lucchesi, when you begin your argument, if you plan to reserve time, just let me know, and I will do my best to keep track of that time for you, because I'll be keeping the clock here. These arguments are being recorded. They will be posted later on YouTube. We have read your briefs. We are ready to proceed when you are.
Thank you, Your Honor. My name is Tom Lucchesi, and I represent Equity Trust Company and the other defendants in this case. I would like to, with the court's permission, reserve 5 minutes for rebuttal.
Okay.
So, Equity Trust, as the court knows from the briefs, is a custodian for self-directed IRAs. It is a defendant, along with the related entity and two of its principals, in a putative class action that was filed in 2013 in Lorain County before Judge Mark Betleski. Over a 4 to 5 week period in 2011, Equity Trust worked closely with its outside counsel, the firm of Ulmer & Byrne, and two lawyers at that firm, to revise the legal instrument that governs its relationship with its customers. That's called the Custodial Account Agreement, and I'll just probably refer to that as agreement as we go through the talk today. During this period of 4 to 5 weeks in 2011, the agreement, working with counsel, the agreement went through 12 drafts as 4 or 5 people from Equity Trust worked closely with counsel and with each other to revise the agreement, which is the legal instrument governing the relationship between the company and its customers. This interlocutory appeal is taken from Judge Betleski's ruling that the majority of the documents at issue, and the court should have a binder of documents, I'll go through that in a minute. Judge Betleski ruled without any rationale or expressed reasoning that most of the revisions are not protected by the attorney-client privilege. The judge's ruling is contained almost literally on a half sheet. It contains no logic or no expression of the court's view of the documents other than to say what is discoverable and what is not discoverable. It appears that for the most part, the trial court determined that communications that were among and between the Equity Trust personnel working on the revisions were not privileged. It looks like the judge mostly, just if there was a lawyer on the email chain, said it was privileged. If there wasn't, he said it was not. That's not totally what he did, because there's some inconsistencies there, but nonetheless, this court takes a de novo review of what the trial court did. We had submitted to the trial court, and as part of the record on appeal, the challenge documents. They're in a binder. There's 50 documents that are subject to the privilege issue. We included in the binder approximately 78 documents. Some additional documents are to give the court context. We also gave the trial court, and it's in the record before your honors, the Ulmer & Byrne invoices so that the court could see the close involvement with counsel in the revision process. Indeed, you'll see that in the 4 to 5 week period in June and July of 2011, when the document was being revised, there were 17 to 20 conferences with the lawyers. It's not always possible to tell if the conferences were by phone. I think most of them were, but there were conferences between the Ulmer & Byrne lawyers and the persons at Equity Trust, a guy named Jeff Bartlett, a guy named Michael Dia, and a few others. There were conferences about the revisions, and thereafter the revisions were then circulated internally and then sent back to the lawyers for further review. And this process went on through 12 versions of the document, and the court can see from what it has that the area being reviewed and being revised is a very specific part of the agreement. It's a very narrow part of the agreement. We also submitted 2 affidavits from Mr. Dia, who at the time was the president of Equity Trust. And Mr. Diaz's affidavit goes through, there's two affidavits. The first one includes the Ulmer and Byrne time entries and validates those documents. The second affidavit actually goes through every single document that's at issue here and explains how it was part of the collaborative process with the attorneys and internally to revise the agreement. And it establishes the basis for our claim of attorney-client privilege for the documents that are at issue. This matter requires the court, I don't think the law is really in contest here. This court is required for this appeal to really look at the factual basis for the claim of privilege. I think the law is fairly clear, and we've cited law in our briefs that attorneys don't need to be present on the communications for them to be privileged, as long as they're in the context of seeking advice from counsel and discussing that advice, furthering that advice, and implementing that advice, which is what we have here. As I said, the record indicates that the revisions occurred over a 4 or 5 week period between June 20th and July 15th, 2011. The Ulmer time records show approximately 20 meetings or conference calls with Equity Trust personnel. Viewed collectively, we can see the communications were all related to revisions to a portion of the agreement. Corporations need to be able to seek legal advice from counsel. They need to be able to discuss that advice in order to understand it and to implement it. We have cited a number of cases in our brief that deal with the issue of discussions and the transmission of advice and communications outside the presence of counsel. The McCall versus Proctor case, Procter & Gamble case, Tovey versus Nike, Graff versus Haverhill, and then some Ohio cases, Schaefer versus Ohio Health, and then Bennett versus Roadway Express, which is a 2001 decision from this court. The legal instrument here, the agreement, is the controlling document between Equity Trust and its customers. The communications at issue relate to the 12 drafts that were being revised, exchanged, and discussed internally simultaneously and in conjunction with ongoing advice and consultation with Mr. Fine and Mr. Kahn at Ulmer and Byrne. As I said, the DIA affidavit actually walks through and explains the relationship of the various communications to the advice of counsel. On page 14 of our appellate brief, we actually break out one series of those communications and show that, minute by minute, there's 1 minute, there's a conversation with the lawyers. The next minute, they're sending drafts to various persons internally, and then follows up with other communications back to the lawyers. The court can see from the documents that the plaintiff raises the issue that these are business discussions, and business discussions are not protected under the privilege. And the court can see from the documents, the plaintiff, of course, is at a little disadvantage because they haven't seen the documents, but there is no business discussion. There may be 1 or 2 lines of discussion outside of the transmittal of the documents, and the court can also see we produced documents where there was discussion about the transmittal. We produced that portion of the emails where there's discussion about the transmittal. But for the most part, what we're looking at is 12 revisions to the agreement between the beginning point and the end when the agreement was finalized in July of 2011. Plaintiffs have in discovery the first document, the pre-revision, and the post-revision document. They can, and they already have done a compare and contrast and created their own red line. So they can see exactly what was changed in the agreement in July of 2011. Plaintiffs are entitled to discovery to find out the facts that led to the revision. And in fact, the plaintiffs have served us with, I can't remember the exact number, I think it's 100 or more, 30B5 deposition topic requests. It might be 80 some. But several of the topics are directed at seeking out the reasons for the revisions. So plaintiffs are well aware. They can find out the facts. We're not trying to hide any facts from the plaintiffs, but they're not entitled to see the iterative process. I'm not sure I said that word right, iterative process between the lawyers and the client as they worked through the draft of the agreement. They're just not entitled to see that. That is protected by the attorney-client privilege, and that is a privilege, Your Honors, that is so basic to our practice of law and so fundamental and so closely guarded and so closely protected that it deserves protection here. And the trial court, frankly, despite taking 20 months to make the ruling, I think did all the parties a disservice by not delving into the documents more deeply.
Well, Mr. Lucchese, on that note, you mentioned that, you know, the law is set here, and I note that you asked for this case to be on this court's accelerated calendar, which normally would mean that we would simply say, you know, the trial court applied the wrong law, the trial court applied the correct law, and, you know, we'd issue a 1 or 2 paragraph decision. How are we supposed to do that here? I've looked at the trial court's decision, as I'm sure, you know, my colleagues have. I'm sure the both of you have. Other than, you know, everything's allowed except for what, 7 and 8, or, you know, I don't know what law the trial court applied. What are we supposed to do? How are we supposed to do that with an accelerated calendar?
Well, I thought that the court you could do one of 2 things. If you're not able to reverse this, well, first of all, let me point out that it was the defendants or the plaintiffs that asked for the calendar to be accelerated, I believe. And we didn't object to that. We're interested in getting this case processed through the trial court. It's been languishing before Judge Bedleski since 2013.
And I also want to let you know you're into your rebuttal time, so I apologize.
Okay, well,
you can answer or not.
I would like, you know, the court, a minimum, send it back to the trial court with instructions on what law to apply. That would be one way to do this, and that would be my suggestion at a minimum.
All right, I'll pause you there. Mr. Scott.
Thank you, Your Honors, and good morning. And thank you for the opportunity to put on a suit and tie. It's a refreshing change.
Wow.
And I will tell you, you can't tell, but I am wearing my pants.
Okay.
So I'd like to help this court understand the current discovery dispute. I'd like to kind of put this in context over the claims and the discovery that has occurred over the last 7 or so years, because I think it will help this court understand what it is that the plaintiffs are seeking and why the court ruled the way that it did. So this court may be, by the way, my name is Stuart Scott, and I represent the plaintiffs as well as the putative class, which is a good segue into what this case is about, because it may be familiar to this court because virtually the same claim was brought before it a couple of years ago in the Bentley versus Equity Trust case. That litigation involved the claims of collusion between Equity Trust and some fraudulent real estate deals where customers of Equity Trust invested in these fraudulent deals through their Equity Trust IRA. This court overturned the court's dismissal in that regarding that claim, and we have very similar claims in this class action. But we also have a second component that the Bentley case did not have, and that is going to be the subject of this discovery dispute. And that claim has to do with how Equity Trust manages and what they do with the hundreds of millions of dollars of uninvested cash that is handed over to them by their customers. Uninvested cash in this context means that the customers, before they direct the money into whatever investment that will be held by the IRA, they first turn over the cash that sits in their IRA. And this money is called uninvested cash because it's not at this point invested. Equity Trust, between 2003 and 2011, took this uninvested cash from all of its customers and commingled it and deposited into a single bank account under an equity trust name. The bank, the name of the bank was Western Bank in Colorado. And Equity Trust and Western Bank had a contract. It's called the sub-accounting agreement. And what the sub-accounting agreement did, and what it says was that the bank would pay Equity Trust fees for every customer who had uninvested cash in the bank up to a maximum ceiling for this entire account that was controlled. The maximum amount that would be paid in fees was controlled by prevailing interest rates set by the federal government. Now, the customers didn't know anything about this sub-accounting agreement between Equity Trust and the bank. What happened for the customers with their uninvested cash was that they were not credited any interest during the time period that their money was sitting in the bank, or if they were credited anything, it was a few cents. What the plaintiffs allege here is that Equity Trust used the cash for their benefit to generate fees from the bank that otherwise would have been credited to this account as interest. And as far as so what the bank was paying Equity Trust to do, as we understand it, was to provide sub-accounting. In other words, to keep track of Equity Trust's own customers' money. And as far as we can tell, there was no duty on the bank to do any of that because it was a single account held by Equity Trust. They didn't know who the customers of Equity Trust were. This would be akin, sort of akin to our law firm going to our bank and telling the bank, well, how much money are you going to pay us in order for us to keep track of our client's money in this trust account? You can predict what the answer would be, and the answer would be, we're not going to pay you anything because that's not our job. In any event, the sub-accounting agreement ultimately paid Equity Trust close to $1 million per month from 2003 until 2011, while the customers received either no interest or very little interest. The agreement between Equity Trust and its customers during that same period of time was silent as to Equity Trust receiving fees that would have been otherwise been credited interest on this account and then credited to the individual customer's account. And that was up until 2011. In 2011, everything changed. The bank failed and then was taken over by the FDIC, who either sold it or merged it with another bank. And then that new bank rejected the sub-accounting agreement with Equity Trust on the basis that it didn't make any commercial sense. This forced Equity Trust to then have to find a new bank to deposit the uninvested cash. And that is when Equity Trust had to change the customer account agreement that is the subject of this discovery dispute. And at the heart of the agreement is something called a cash management program. So what Equity Trust ultimately did in this new customer account was it disclosed under the cash management program that Equity Trust would be getting paid, I believe it was $40 a month of per account from the interest earned on the customer's account. In other words, the interest that was credited to the individual's cash would be used to pay this $40 a month for Equity Trust to perform the sub-accounting, which was on top of the hundreds of dollars of fees Equity Trust was already charging its customers to maintain the IRA accounts and to keep track of what was owned in these accounts. So that's the backdrop for the plaintiff's discovery request that asked for all documents, memos, emails, letters, anything that was related to the cash management program and the new agreement. To date, from those discovery requests, nothing has been produced that discussed anything whatsoever about the cash management program, why it was created, what the purpose was, what type of service it provided to the customers, if there was any benefit to the customers, whether this was in some way different than what Equity Trust had been doing prior to 2011. Plaintiffs have none of this information in documentary form. So I tell you all of this to try to put the current discovery dispute into context. So the documents, as I understand it, and as counsel properly indicated, I'm at a little bit of a disadvantage because I haven't seen the documents, but from what I can understand, there's basically 4 categories of documents. One category of documents are the account drafts between counsel, outside counsel to Ulmer Byrne, who was characterized as a de facto in-house counsel, but was actually outside counsel. But drafts of the new agreement between counsel and Equity Trust. We then have, as I understand it, account agreements that were drafted in-house by Equity Trust people and then communicated to other non-lawyers within the company. The third set of documents are communications, which I understand to be basically emails, between Equity Trust and the outside counsel. And the fourth set of documents are communications internal to Equity Trust between non-lawyer employees. So the legal standard that applies is, I think counsel properly characterizes, the law is not really in dispute, but what the cases all caution courts to do is to carefully look at the documents and the facts surrounding those documents to determine whether in fact the privilege applies. So it's worth mentioning what I think are the 4 primary principles of law that are applicable to the documents in this case. One is that Equity Trust has the burden of demonstrating by substantial evidence that the communications would qualify as privileged communications in the first instance. They have the burden of showing that the communication was for legal advice as opposed to communicating simply business interests or simply underlying facts about the business itself. Also, to the extent the communications are between non-lawyers within the Equity Trust company, Equity Trust must demonstrate 2 things. Number one, that the predominant purpose of those communications was seeking legal advice. And that comes from the Wilkinson versus Greater Dayton case cited by both plaintiff and defense here. The second principle that applies to non-lawyer employees is that to the extent the communications are between non-lawyers, Equity Trust must demonstrate by substantial proof that the employees communicating knew it was the purpose of the communication was to obtain or provide legal advice at counsel's request. And this comes from the Graf Haberhill case, also cited by defendants. So that brings us to the analysis of how do we apply the law to these 4 categories of documents. So the first analysis and type of document are the internal communications. So these can only be privileged if both the senders and receivers understood that the primary or predominant purpose of the communication was to obtain or communicate legal advice. In addition to that, there must be knowing or knowledge on these non-lawyer senders and receivers of the communication that the purpose of it was to obtain advice from counsel. So there's 2 things that have to be fulfilled in order to say the privilege would apply between communications internally between non-lawyers. So then based on the record before this court, we have affidavits from Mr. Dea, but that affidavit only speaks to his belief or understanding of his communications with counsel and other employees. It doesn't speak to the other employees who were involved in communications that are the subject of this dispute, because we don't have any affidavits from those other employees who are non-lawyers. We have no information about what those people thought they were, what the purpose was in their communicating these emails back and forth internally. So they have not met their burden of demonstrating by substantial proof that the internal employees knew they were communicating for purposes of seeking or using legal advice, because there's no proof to demonstrate that. The only evidence we have is as to Mr. Dea's own belief, and to the extent he's communicating with other employees, we don't know what the other employees' understanding or belief was as to those communications. And of course, the other thing the court needs to use, the lens that they look at these documents with, is, are these communications truly predominantly about seeking or offering legal advice? This applies both to the, I'll call, pure email communications, as well as the drafts of the customer account agreement that were being circulated internally. As I understand it, there were drafts created by employees who were then circulated to other employees for their input and guidance. Those versions or those drafts do not have attorney-client privilege protection, because they have not demonstrated by substantial proof that the employees circulating or communicating those drafts felt or believed or understood that it was for purposes of seeking legal advice. Now, with respect to the communications between Equity Trust and outside counsel, generally speaking, those communications would be afforded the privilege, and those documents would not be discoverable. However, the court needs to take a close look at those communications, because if those communications are also communicating specific facts about the business, or communicating information that would be basically business information about how they conduct their business, the purpose for the cash management plan, things that are really go to more of a business nature, the court has the discretion under those circumstances to, instead of denying entirely the document, to have the document redacted, redacting the attorney-client communication parts, while still allowing discovery of the underlying facts. And that, in this case, it's particularly important because, as I said earlier, our discovery to date has not yielded anything useful about why Equity Trust was changing their documents or how they ran their business with respect to cash management plan, either before or after 2011. And yes, Mr. Lucchese says, well, they can take a deposition, but this is a deposition a decade after the facts, the things that occurred. And it's much easier to whitewash what actually happened back then if there are no documents that were created, no business documents created contemporaneously that would explain what was really happening and what the understanding of the company was.
Mr. Scott, you're well past your time right now. I'll give you a wrap-up statement if you'd like to make a brief wrap-up statement. And
very brief. Yes, I understand that the trial court didn't give this court much guidance in terms of its thought process, but it's a de novo review. And from my understanding of the documents that were permitted for discovery and held back, the court in fact followed the law that I've just outlined and analyzed those documents correctly, because there was a lack of substantial proof that the internal communications were in fact privileged, because the people doing the communicating, there's no evidence that they thought they were doing it for purposes of attorney-client privilege. Thank you.
all right, thank you. And Mr. Lucchese, you have 3 minutes and 48 seconds, but I'll let a little more go on to that because opposing counsel had a little more time.
It was your fault I went over, Your Honor. So you asked a question right when I had 30 seconds left. So
you're good. Keep going. You're fine.
I'll be brief. Mr. Scott spent a significant amount of his time talking about his version, and I emphasize the plaintiff's version of the merits of the case. And the plaintiff's view that perhaps they don't like what they got in discovery, and he claimed we were whitewashing, which we're not. But none of that is relevant. None of that is relevant. This is a question of whether the information they seek, the information that's in the binder before the court, is attorney-client privileged or not. Whether the plaintiffs really need it, really, really bad, doesn't matter. Okay, this is a question of privilege. This isn't a question about the work product protection where the plaintiff's need for the information can outweigh the work product protection. This is a privilege question, fundamental privilege question. So everything that Mr. Scott talked about, talking about the Bentley case and the background of this case, it's all irrelevant. This court needs to just look at what was submitted to the trial court, and did we carry our burden? I agree with him. We have the burden of showing this was privileged. And through the combination of the review of the documents and the DIA affidavit, and looking at the timing and the sequence of events vis-a-vis the conversations with Ulmer and Byrne, which were ongoing and continuous, it's perfectly clear that everybody was on the same page. Everybody knew in the circle of people working on this at Equity Trust, everybody knew they were working with counsel. Counsel talked to DIA. Counsel talked to Jeff Bartlett. Counsel talked to the Desiches, which are the principals, Jeff and Rich Desich, the principals of the company. They were the four people that had 98% of all these communications. There's no mystery that they were working with counsel, and they knew they were working with counsel. And DIA points that out in his affidavit. We don't need to get an affidavit from every single employee. I disagree with that. I think we've carried our burden of showing that the information was exchanged in conjunction with advice of counsel, in furtherance of advice of counsel, and in implementation of advice of counsel. And you'll see the implementation at the very end of the timeline. There's a woman named Wampelman, Kim Wampelman, and a woman named, it's either Tollet or Tollette, Renee, I think is her first name. They were responsible for getting the words in the final draft of the agreement that gets sent out to all the customers. And you'll see they're brought in at the very end, and there's a couple of revisions with them. They too knew this was with counsel, and that is explained in Mike Dia's affidavits. So, it is unfortunate that this was an expedited appeal. To be honest, I did not know the court was limited in how it could decide an expedited appeal. As I said, the plaintiffs asked for it to be expedited. We are not trying to delay the litigation. The trial court is doing a good job of that on its own. We would like this case to move forward. I know Stuart would like this case to move forward. We're both kind of frustrated with the pace of this case. But the fact is the plaintiffs can discover the facts that underlie the reasons. And you'll see at tab 4, we produced one of the documents that's at tab 4, discusses, it's just 2 sentences, but it discusses a business reason for the revision, saying that we're looking at what our competitors are doing. That was a document that was produced to the plaintiffs. The fact is there aren't a lot of documents, and we're not hiding the ball. And again, even if we were and we have discovery disputes, that's irrelevant for what's before this court. We may be back before this court on some other things in the near future because there's other documents that are subject to privilege questions that are pending before the trial court. So I think it's important for that reason that this court, tell the trial court what to do, because the trial court's looking at a lot of documents, and we're going to be back ping-ponging back and forth in this case as we work through the issues. So I appreciate the court's attention and consideration of our position here. Thank you, Stuart, for your words. And we've got along very well in this case, but we just have a disagreement, on this point, and we're looking for some help from this court.
All right. Well, thank you both for very good arguments. We will take the matter under advisement. We will issue a written decision in due course. I will tell you that just because there is a request for accelerated calendar, we do not necessarily have to honor that request. We'll have to wait and see where this goes. Both sides will get a copy of our opinion, and it'll be posted on our website and that of the Supreme Court. This court